Your Honor.
Yes, ma'am.
Mr. Manning needs about 10.
He needs what, 10 minutes?
Yes, sir.
I'm telling me you have not.
9. Okay, thank you. All right, we gave you a minute back.
All right, Mr. Manning, who are we ready?
Is ready on Mr. Roy Mitchell.
All right, this is cause number CR 25-183, State of Texas versus Roy Mitchell III. Is Mr. Mitchell entering a plea today?
He is, Judge.
All right, let me go find that plea. Mr. Mitchell, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Just one moment here. All right, your name is Roy Mitchell III, is that correct?
Yes, sir.
And Mr. Mitchell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you?
Yes, sir.
Do you have any questions about your plea agreement?
No, sir.
Mr. Manning, do you believe your client to be competent? And if so, that he's entering into this plea intentionally, knowingly, and voluntarily after being informed of his rights?
I do, Judge.
All right, Mr. Mitchell, I see that you are charged by indictment with a second-degree felony offense of assault of a peace officer or judge. It appears that offense was enhanced by some allegations of a previous conviction to a first-degree felony assault of a peace officer. I see that the range of punishment is not less than 5 years in prison and not more than 99 years or life in prison. And your plea agreement in this case appears to be, upon you pleading guilty, the state's recommending that the court consider the evidence, that the court convict you of this offense, that the court assesses your sentence at 8 years confinement in the Texas Department of Criminal Justice, a fine of $1,000. The DA's office would be asking the court to dismiss a resisting arrest, search, or transport that's unfiled at this time. You would be pleading true to the prior allegation of conviction, and you would also be responsible for court costs of $290 and reimbursement fees of $20, and you would be entitled to any jail credit towards your sentence for time that you've already spent in jail on this case prior to your plea. Mr. Manning, what is the proposed credit time?
Judge, the credit time that we have listed for, I apologize. Is it 141? $144 credit, Judge.
144.
That's correct, Judge.
Mr. Mitchell, you would receive 144 days credit towards that 8-year sentence for the time that you spent in jail. Mr. Mitchell, is that your understanding of the plea agreement and what you're asking the court to approve?
Yes, sir.
All right, Mr. Manning, do you believe Mr. Mitchell to be competent? I'm not sure if I've already asked you that.
You've already asked that,
Okay,
Judge.
I'm sorry. All right, so Mr. Mitchell, at this time, how do you plead to assault of a peace officer? How do you plead to that crime? And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Mitchell, with regards to the allegation of a prior conviction, is that enhancement paragraph true or not true?
Sure.
All right, has anyone threatened, forced, or pressured you to plead guilty or true today?
No, sir.
All right, the court will accept the defendant's plea of guilt to the offense of assault of a peace officer. The court accepts the defendant's plea of true, finds that increases the range of punishment to first-degree felony. Mr. Manning, is there any objection to the admission of evidence?
No, no objection as offered.
All right, then the court admits the stipulation of evidence. Anything further from the state?
Your Honor, only that law enforcement is supportive.
Thank you, Mr. Hartwell. Anything else from the defense?
Rest and close, Judge.
All right, the court does take judicial notice of the defendant's judicial confessions. All right, the court's going to review the evidence at this time. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of the offense. The court will follow the plea agreement and recommendation. Court hereby convicts the defendant, Roy Mitchell III, of assault of a peace officer. Court finds the prior enhancement allegation to be true. The court assesses punishment for a first-degree felony at 8 years confinement in the Texas Department of Criminal Justice. Orders the defendant to pay a $1,000 fine. The court also orders court costs of $290 and reimbursement fees of $20. The court does dismiss DA 2025-726, resisting arrest, search, or transport in conjunction with this plea. The court awards the defendant 144 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Mitchell, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Mr. Manning, while I'm signing this, if you want to go ahead and bring your next client.
Yes, Judge. We'll start with, would you like to continue with, please?
However you want to do it, whoever you are ready.
Judge, we'll be ready on Mr. Crowder.
Okay.
Yeah.
All right, this is cause number CR 25-242, State of Texas versus Kavondre Shaquillin Crowder. Mr. Crowder, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. All right, your name is Kavondre Crowder, is that correct?
Yes, sir.
And Mr. Crowder, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you have any questions about your plea paperwork that you signed and read?
No, sir.
All right. And Mr. Manning, do you believe your client to be competent today? And if so, that he is entering into this plea intentionally, knowingly, and voluntarily after having been informed of his legal rights?
I do.
And it looks like Mr. Crowder would be waiving his right to an indictment and allowing the state to prosecute him by information. Is that correct?
Right, Judge.
Okay. All right, Mr. Crowder, I see that you are charged by information with a felony offense, a third-degree felony offense of driving while intoxicated, third or more. A third-degree felony carries a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a possible fine not to exceed $10,000. Mr. Crowder, you've not been formally indicted by the grand jury of Van Zandt County. And it's my understanding that you're asking the court to approve your waiver of indictment and allowing you to resolve your case by letting the state charge you with a legal instrument called an information rather than an indictment. Is that true?
Yes, sir.
You understand, Mr. Crowder, that the only person that can waive an indictment is the person who's being accused, meaning your attorney can't do it, I can't do it, the DA's office can't do it. You and only you can do it. And in order for you to waive your right to an indictment, I have to make sure that you understand that once you waive that right to an indictment, it may not be given back to you, and that you would be waiving your right to have a grand jury review the evidence to determine if they believe that there's enough probable cause to believe that you have committed a crime to hold you over for prosecution and trial. Do you understand all those things, Mr. Crowder?
Yes, sir.
All right. Mr. Crowder, has anyone threatened, forced, or pressured you to waive your right to an indictment?
No, sir.
All right. The court finds that the defendant has been admonished regarding his right of indictment. Mr. Manning, you are joining your client in his waiver, correct?
That is correct, Judge.
All right, very well. All right, the court does approve the waiver of indictment and will allow the state to proceed with their prosecution by information. I see that your plea agreement today, Mr. Crowder, is upon you pleading guilty to the offense. The state is recommending that you be sentenced to 3 years confinement in prison, along with a $1,000 fine, plus court cost of, let me back up. Looks like your fine is $5,500, with $1,000 being a general fine, and then a fine of $4,500 being a DWI traffic fine. In addition to that cost, you would also have court costs of $290 and reimbursement fees of $30. As part of your plea agreement, the state is they're asking the court to take into consideration and dismiss another indicted cause, CR 25267, which is a terroristic threat against a peace officer, and the state is also agreeing to reject a resisting arrest, search, or transport. Mr. Crowder, is that your understanding of the plea agreement in this case?
Yes, sir.
And Judge, if I may, at this time, I ask the court to take judicial notice of my client's indigency status. That is obviously continued as he has remained in custody. And so we'd ask under the law, he be allowed to continue in that indigency, the finding of indigency be applied for the super fine under the traffic code.
State.
Your Honor, state has no objection. The law sets out the requirements for the court to make findings. If the court makes that finding, state has no objection.
All right. I do have a question about restitution. The terms of the plea bargain and the judgment indicate a $60 restitution, but there's no restitution laid out in the financial portion of the judgment. It says restitution $0.
Your Honor, I think that was just a missed on our part. That should be going to DPS for blood labs.
60.
And Judge, it does show on his bill of costs, it does show the $60 assigned as restitution.
All right, so we'll need to do a nunc pro tunc on that order on the judgment since he's going to TDC.
Yes, sir.
All right, then Mr. Crowder, how do you plead to driving while intoxicated, third or more?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the admission of the evidence?
No objection as offered.
All right, then the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from state?
Nothing further, Your Honor. Thank you.
Anything further from the defense other than the request on the superfine?
Judge, just that he has 97 days credit.
Oh, great, thank you. All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement today. Court hereby convicts Kevondre Shaquillin Shakur Crowder of driving while intoxicated, a third or more offense, a third-degree felony. Court assesses punishment at 3 years confinement in prison, orders him to pay a $1,000 general fine, restitution of $60, a DWI traffic fine of $4,500, court cost of $290, and reimbursement fees of $30. Further, the court does dismiss under section 1245, cause number CR 25-267 and DA 2025-0983, those crimes being a terroristic threat against peace officer and a resisting arrest, search, or transport. And the court awards Mr. Crowder 97 days credit towards his sentence for the time that he's already spent in jail on this cause. The court, having considered the defendant's request to waive the traffic fine, is denied by the court. Mr. Crowder, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingered. All right, Mr. Manning, I'm going to sign these if you want to go ahead and bring your next client.
Next, we'll bring up Vincent Odell.
Right, this is cause number CR 25-170, State versus Vincent Everett Odell. Mr. Odell, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. Mr. Odell, your name is Vincent Everett Odell, is that correct?
Yes, sir.
And Mr. Odell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Any questions about your plea agreement or any of the paperwork you signed?
No, sir.
Mr. Manning, do you believe Mr. Odell to be competent? And if so, that he's entering into this plea agreement intentionally, knowingly, and voluntarily after having been informed of his legal rights?
I do.
All right, Mr. Odell, I see that you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram, less than or equal to 4 grams. And however, I see that there is a agreement in your case wherein you're asking the court to, along with the state, to allow you to plead to a lesser included offense of possession of a controlled substance less than 1 gram to be prosecuted as a felony, but punished as a misdemeanor under section 1244A. It appears that the recommended sentence from the DA's office is 240 days in the county jail, for which you would be receiving credit of 212 days. Also part of the plea, you would be ordered to pay restitution of $180 and court cost of $290 with reimbursement fees of $512. Mr. Odell, is that the plea agreement you're asking the court to approve?
Yes, sir.
All right, understanding those things, the range of punishment for a Class A misdemeanor is up to a maximum 365 days in the county jail. So, Mr. Odell, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram, a lesser included offense under section 1244A?
Guilty, Your Honor.
And Mr. Odell, has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection is offered.
Evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court is reviewing the evidence at this time. All right, the court finds that there is sufficient evidence to convict the defendant of the offense. The court will follow the plea agreement and recommendation. Court convicts Vincent Everett Odell of possession of a controlled substance in penalty group 1 less than 1 gram, state jail felony. Court assesses his punishment under section 1244A at 240 days confinement in the county jail. The court issues credit towards that sentence of 212 days. Court orders the defendant to pay restitution of $180, court costs of $290, and reimbursement fees of $520. Mr. Odell, once you are released from the Van Zandt County Jail, or if you do have to, well, it's under 1244A, so you'll be released from the Van Zandt County Jail. Once you're released, I need you to report to, and I'm ordering you to report to the district clerk's office so you can make arrangements to begin a payment plan, unless you can pay off all of your restitution, fines, and court costs at the same time. I order you to enter into a payment plan. Otherwise, failure to do that may result in you being rearrested and incarcerated for failure to follow the court order. Do you understand?
Yes, sir.
All right. Mr. Odell, you're hereby referred to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted.
Thank you.
What do you want next, Mr. Mann?
Judge, if we can take up Mr. Ibarra. Judge, I've recently been appointed, or I've not.
Hang on just 1 second. I've got to sign these plea papers and then let me call the case and get it on there.
So,
All right, this is cause number CR 25-88, State versus Joshua Andrew Ibarra. Court finds that Mr. Ibarra is incarcerated on the state's motion to revoke. The court finds that the Honorable Jonathan Manning has been appointed to the defendant, and the court has found him to be indigent for the purposes of the Sixth Amendment. Court hereby resets Mr. Ibarra to the court's evidentiary docket on January 22nd. Is that the date you want, Mr. Manning?
That's fine, Judge.
All right. If there's a resolution and we need to get it set sooner, you'll notify the court and we'll make it sooner.
Well, Judge, I would ask, it looks like we've also got a new indictment, and so I don't know if we want to run those together as well. I anticipate it's going to take a little bit of time for me to get the discovery as well as prepare, as this case has been alleged to be a habitual felon offender case.
All right. Has he been arraigned on the new felony case?
Not that I know of, Judge.
Okay. Do we have, Ms. Tabraham, is that one of them that you were telling me about today?
Judge, I've been provided a copy of the indictment. If I may just have a moment, I can go over that with my client.
Yeah, go ahead and read me that cause number so I can write it on the docket.
CR 25-263,
Thank you.
and that was indicted November 21st of this year. So, said they're alleging a felony, I believe. What date it is. Out of 2024, out of oh, sorry. No, you're right. Out of here. So that'll be said, like I said, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment, and his plea is not guilty at this time.
All right, court finds that in cause number CR 25-263, the defendant has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record. The court will set that case for pretrial on February 5th. Is that acceptable, Mr. Manning?
Yes, Judge.
February 5th, and we'll set the motion to revoke on the same date, February 5th.
Thank you, Judge.
All right, who's next?
Mr. Walter Baird.
All right, Mr. Beard.
Or sit behind me.
All right, this is cause number CR 25-153, CR 25-164, State versus Walter Lynn Baird for pretrial.
Yes, Judge. I have been in trial over the past month, and I'm preparing for trial next week. I've not made it to the DA's office to view what I understand is a large amount of material that can only be viewed at the DA's office. I request additional setting for pretrial in this case.
Any
No
objection?
objection, Your Honor.
All right, court will reset Mr. Baird then for pretrial February 5th at 1:30. Who's next, Mr. Manning?
Judge, next, Mr. Barentine.
Joseph Lee Barentine, cause numbers CR 25-192, 193, 194, and 226. Let's see, I got Mr. Barentine set for pretrial in the first three, and the most recent case I have him set for arraignment. Have you had an opportunity to review the indictment on the manufacturer, delivery, controlled substance 200?
Judge, I have not had a chance to go that with him. I was provide a copy when I got to the jail today. I may just have a moment.
Yes, sir.
Yes, sir. Okay. They just denied you on the first. I received the indictment. Okay. So it's 10% of the life passing alleged it. $200,000. Whatever.
Your Honor, may I have a brief word
Okay.
with you, yes, sir?
No, sir, it wouldn't be appropriate.
On 10/16/2025
No,
at the
sir.
1:30
No,
PM.
sir.
Van Zant
You can keep on talking, but I've got you on mute. I'm not listening to anything you've got to say. You need to speak with your attorney, Mr. Manning. Mr. Manning, we have his tape ramp unmute the Joe port. Mr. Manning, if there's anything that is of legal concern that Mr. Barentine tried to disclose, I'm confident as an officer of the court, you will handle that. I did mute him immediately, so I did not hear what he had to say. Was not inclined to listening to any of that.
Yes, Judge.
And so, did you have a chance to explain to Mr. Barentine, what he was charged with in cause number CR 25226, the range of punishment?
Yes, Judge. He had he relayed to me while we were just conferencing about the new indictment that he had received a copy of the indictment, was aware of the indictment. So on his behalf, I plead not guilty. Request to be set. All these cases be set for pretrial at the court's next sitting.
All right, court will enter Mr. Barentine's plea to not guilty in cause number CR 25226. Court will set all matters for pretrial on February 5th at 1:30. All right, who's next? Who do you want next, Mr. Manning?
Judge, if we can call Mr. Nicholas Deal.
Nicholas Ryan Deal, CR 25-227, 228, and 229. Mr. Deal is set for pretrial. Go ahead, Mr. Manning.
If I may just have one moment, Judge. Judge, my notes show that we are going to request to proceed to docket call. We are in ongoing conversations with the DA's office regarding negotiations on this case. But my client would request to move on and proceed to docket call.
All right, and you said you're in trial on the 8th, right? January 8th?
Judge, I believe so. That was from memory. Let me check my calendar if I may. Sorry, Judge. I'm in trial that next week, and the trial that I had that week has gone away.
Okay.
With the plea in Kaufman County.
All right, any objections to setting Mr. Deal then on the 8th?
That would be fine, Judge.
All right, court sets Mr. Deal for docket call on January 8th at 1:30. All right, who's ready, Mr.?
Judge, this is Mr. DeMarcus Hyder.
All right, this is cause number CR 25-205 and CR 25-209. I'm sorry. Just CR 25-205, State versus DeMarcus Leon Hyder for pretrial. Go ahead.
Judge, and I apologize. I am going off my notes here at the moment, but I showed that we were going to reset pretrial for additional discovery. I believe the state had communicated to me that there was additional discovery on Mr. Hyder's case. They provided within the last week. I've been unable to go over that discovery due to trial preparations. So we would request additional pretrial for me to review that discovery that was provided by the state.
All right, do you already have it, or do you have to review it at the DA's office?
Judge, I honestly, like I said, I'm just based off my notes, I believe this is something I can view at my office. I just haven't had the chance to do that due to the holidays and trial prep.
Sure. Do you want 1-8 or 2-5?
If we can keep it on the shorter 1-8 docket, so I can, if I do get a chance to review it, and it leads us to some conclusion, he's not sitting here longer than he has to.
All right. Court will set Mr. Hyder then for docket call January 8th at 1:30.
So I don't know what.
I showed in the blue. I'm showing in the blue on everything, man. I'm confused. How you got it? Well, we didn't go.
No, I got the stuff. They find new stuff in this. At the original packet, but I did find more stuff this last week. Next judge ready on Mr. Cody Lassiter.
All right.
I guess.
Mr. Lassiter in there?
Yeah.
All right, this is cause number CR 25-209, State versus Cody Ryan Lassiter for arraignment.
Judge, Mr. Lassiter's name is spelled correctly. He understands the charge against him as well as the range of punishment, pleads not guilty. Additionally, Judge, I have gotten access to the discovery and have begun negotiations with the state that I hope to be dispositive for Mr. Lassiter's case.
Would you like pretrial 1-8 or 2-5?
Judge, if we can keep it on that 1-8 docket, I'd like to keep this one moving.
All right, court sets Mr. Lassiter for pretrial January 8th at 1:30. Who's next, Mr. Mayor?
If we can do Mr. Clint Mills.
Clint Wayne Mills, CR 25-235. All right, Mr. Manning, he is set for pre-trial today. I understand that you have filed a motion for an evaluation.
That's correct, Judge.
All right, court is granting that motion, and I will sign the order to appoint an evaluator, and we'll get Mr. Mills evaluated. Let's reset this for status of evaluation on, well, let's just do February 5th. That should give Dr. Ingram time to get down there.
Yes, Judge.
All right, who's next, Mr. Manning?
Judge, ready on Mr. Earl Mosley.
Mr. Mosley. Clause number CR 25-236, State versus Earl Eugene Mosley. And Mr. Mosley set for pretrial.
Yes, Judge. We have no contested pretrial matters at this time. We request to be set on docket call.
Got that 1-8.
Yes, Judge.
Court sets Mr. Mosley then for docket call January 8th.
Have you? No. Why do you let me stay?
1-8. Mr. Mosley.
All right, who's next, Mr. Manning?
What is it?
Judge, next, we're ready on Mr. Well, if we can call Mr. Ogletree, I have not been given a copy of the indictment, and he has just been transferred from TDCJ. So I may just need a moment to discuss that with him.
All right, do you want me to get an indictment ready?
Judge, if you don't mind, I don't think I've been given access yet.
Yeah, I'll stand by and I'll get one on the screen for you.
So this is. Judge, if we can scroll down just a little bit, thank you. Your Honor, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment. His plea is not guilty. Request discovery so that we can prepare for this case.
All right, the court will enter the defendant's plea of not guilty into the record. Court hereby sets this case for pretrial hearing on February 5th.
Judge, if we may, if we can keep it on that short setting on January 8th.
Very well. The court will set Mr. Ogletree then for January 8th. All right, who's next?
Judge, next is Mr. Patrick Richardson.
Patrick Lee Richardson, CR 25-186, or docket call. Go ahead, Mr. Manning.
Judge, I've provided the state with information that would support the defenses alleged or that are being raised in regards to these allegations. And I don't know if the state has had an opportunity to review those and make a decision, or if they need additional time.
If we could get one additional setting, Your Honor, to be able to thoroughly investigate it.
All right, court sets Mr. Richardson then for docket call January 8th, 1:30. Who's next?
Judge, next we've got Judson Wilson.
Judson Wayne Wilson, CR 24-227. Mr. Wilson is set for pretrial.
Yes, Judge, we have no contested pretrial issues. Request to be moved to the docket call. Additionally, Judge, I provided evidence of a defense to the state we wish them to consider. And hold on just one moment.
Yeah, you need to come home.
Judge, with that, we request the January 8th setting.
All right, court sets Mr. Wilson in both cause numbers CR 24-227 and 228 for docket call on January 8th at 1:30.
You have to see. That's not something. Yeah, even the picture. And.
All right, Mr. Manning, who's next?
Okay. Thank you.
They have to look at their case.
Okay, right.
Yeah. Okay, Judge, they've just brought in Ms. Gonzalez.
Court calls State of Texas versus Danielle Nicole Gonzalez. Cause numbers CR 25-231, 232, and 233. Ms. Gonzalez is set for pretrial in each case.
And Judge, if I may just have one moment, I was provided some information I have not had a chance to talk to Ms. Gonzalez about.
Yes, sir.
If I may just have a brief second.
Yes, sir.
Thank you.
You're welcome.
All right, on Ms. Gonzalez, go ahead.
Yes, Judge. Ms. Gonzalez has received a plea offer. I've discussed that plea offer with her, and she would like a little additional time to consider that. If we set her for January 8th, that should give her time to consider it for me to go over possible implications of that plea offer and for her to make a decision.
All right, court will set Ms. Gonzalez for docket call January 8th, all three cases.
Thank you, Judge.
Ms. Abraham, does that conclude our afternoon docket at the jail?
Yes, Your Honor.
Judge, if I may, actually, I do have one issue for trial next week. I filed a couple of motions that I guess we're gonna have to. I'm trying to. Well, first let me begin. I spoke to the state regarding the videos and reaching the agreements, and I was informed, and if this has changed, I was informed this morning that the state did not plan or anticipate of offering any videos, so we won't have video issues in preparation for trial. Um, uh,
Does the defense plan on offering videos?
no, Judge, not at this time. The videos that would be allowed if the state had offered them would not be permitted for the defense to offer without some additional exception to the hearsay rule.
Okay. Mr. Hernandez,
Uh,
is that the state's position won't be offering any videos, so there won't be any need to redact videos and deal with any kind of redaction issues?
I don't anticipate any at this time, Your Honor.
Anything else, Mr. Manning?
Yes, Judge. Additionally, there was a recent election, or I'm sorry, the word's escaping me, but designation of expert witness as well as designation of an outcry witness. And the defense has reviewed both those motions and has filed an objection to the expert witness, additional expert witness on multiple grounds, as well as would have an objection to the amended outcry notice that's been filed recently. In speaking to the state, I think that's something we can take up on the Monday afternoon after we select a jury. The one concern I had was that the state said that their witnesses were not going to be available or had not been requested to be there at that time. So I don't know how the court would like to proceed, knowing that we have witnesses that would need to be present for that hearing.
So the defense needs the state's witnesses there for testimony on the motion?
Well, I anticipate the state has a burden to prove and support their outcry witness, as well as I think to respond to defense's objection to their expert witness. So I would anticipate the state may want their witnesses there, or to respond to the objection made by the defense in both those issues.
Mr. Hernandez?
Your Honor, the subpoenas that went out were for Tuesday, not Monday, in light of the fact that the court generally allows us to pick a jury and then we handle any other issues like we have in the past. The court's track record is those expert objections generally mean that we have to, do a little hearing outside the presence of the court, the jury, in order to have the court make a determination as to whether our experts will be allowed to testify. That's what I anticipated, and for that very reason, all of my witnesses are not subpoenaed until Tuesday morning.
We'll just take it up as we have customarily. We'll just
Yes, Judge.
go outside the presence of the jury and allow the defense to argue their motion. If we need to hear the expert witness or the outcry witness, we'll do so that time. I appreciate you bringing it to my attention so that we'll know to plan for that logistically.
Yes, Judge, and like I said, those were filed after review, after receipt of the new information from the state and review of the case file. Like I said, I don't anticipate they'll take long, but I was just trying to keep things streamlined, given our recent trial.
Yeah, I appreciate that. And if it does become an issue on admitting videos, then work together and come up with your redactions. Try to do that earlier than during trial, and then that will speed line it so that or streamline it so that the jury can hear all the testimony without being broken up. But if there's not going to be a video, great. But it's best to go ahead and have a video prepared in case either side wants to admit it. So what I'm saying, Mr. Manning, is if the state doesn't want it and you want it, then go ahead and prepare your video and let the state, I know you don't have to let the state know what evidence you're bringing in, but it may be advantageous to go ahead and maybe speculate on what would be admissible or inadmissible in that video and be prepared with a redacted copy of it.
Yes, Judge.
Okay. All right. Anything else?
Nothing from this defense.
Okay. Anything else, Mr. Hernandez?
No, Your Honor. Thank you.
Okay. All right. You're very welcome. And I appreciate y'all's work today. Thank you, Mr. Hartwell. Thank you, staff at the jail. Thank you, Ms. Taberham and Sergeant Martinez. And we are adjourned.
Thank you, Judge.